and this relates to the changes in the Senate Majority Party leadership. Now, Honorable Senators, via the letter reference number SEN/035/SBC/012/2025, dated 2nd December 2025, I received correspondence from the Senate Majority Leader, Senator Aaron Cheriot, EGH MP, regarding changes in the Majority Party leadership affecting the office of the Senate Majority Whip. As you're aware, Standing Order 22.5 provides as follows. A senator elected under paragraph 1 may be removed by a majority of votes of all the senators belonging to the majority party. Further, Standing Order 22.7 states as follows, that upon a decision being made by the majority party or coalition under this standing order, the decision of the party or coalition shall be communicated to the Speaker in writing, together with the minutes of the meeting at which the decision was made. A, in the case of the removal of the Senate Majority Leader or the Deputy Senate Majority Leader by the Senate Majority Whip, and B, in the case of removal of the Senate Majority Whip or the Deputy Senate Majority Whip by the Senate Majority Leader. Now, Honorable Senators, pursuant to Standing Order 22.7, the said letter from the Senate Majority Leader was accompanied by the following documents. 1, minutes of the Majority Party meeting dated the 2nd of December 2025, which is a record of the proceedings of the minute together with resolutions, and 2, duly signed list of senators who attended the above indicated meeting. Now, from the correspondence, the minutes indicate that a resolution was passed to remove the Senate Majority Whip, Senator Dr. Boni Khalwale, CBS MP, in accordance with Standing Order 22.5. The minutes further indicate the Majority Party elected Senator David Wafula Wakoli MP to serve as the Senate Majority Whip in his place. Now, Honorable Senators, Standing Order 22.8 provide as follows. The Speaker, upon receipt of the decision under paragraph 7, shall verify the correspondence received and deliver communication to the Senate within 3 sitting days. In this respect, I have verified the correspondence received and hereby communicate that the Majority Party has effected a change in the office of the Senate Majority Whip. The new office holder, therefore, with immediate effect is Senator David Wafula Wakoli MP. I thank you. Next order.
Order number 3, messages. Order number 4, petitions.
Now, Honorable Senators, pursuant to Standing Order 232, 1A, I hereby present a petition that has been submitted through the clerk by Mr. Dixon Miano on behalf of other petitioners regarding unlawful and unjustified land rates in Kahawa Sukari, Kiambu County. As you're aware, Article 1191 of the Constitution, and I quote, every person has the right to petition Parliament to consider any matter within its authority, including to enact, amend, or repeal any legislation. The silent issues raised in the said petition are as follows. That the petitioners are residents of Kahawa Sukari in Kiambu County, that the petitioners are concerned about the excessive increase of land rates imposed by the county government of Kiambu, that the county government has implemented a 1,000% increase in land rates, raising annual charges from 10,000 to 15,000. The increase is based on a 0.1% valuation rate, which residents consider excessive, unfair, and economically burdensome. That the residents were never notified of the intention to revise or increase the land rates. They further assert that the increase lacks proper legal and valuation basis as required by law. That despite the legal requirement for county governments to prepare a valuation rule and facilitate public participation, residents remain unaware of whether the rule was prepared, as they have been unable to access it at the county offices. They do not know of the basis for the land valuation and are not aware of any public participation conducted during its preparation. That the petitioners argue that the entire valuation and rate-setting process violates constitutional requirements, particularly public participation, transparency, and accountability. Multiple attempts to obtain information from the county offices have been unsuccessful. The residents state that the services supposedly funded by the land rates, such as waste management, road maintenance, and general infrastructure, are poorly delivered or not delivered at all, making the steep increase unreasonable. That the residents approach the Kiambu County government, the county assembly, and the area leaders, but have received no response and no action has been taken regarding this matter. That the matter is not pending in any court, legal, or constitutional body. That the petitioners therefore pray that the Senate does the following. 1, investigate how the county government of Kiambu set the new rates and determine whether the increases are justifiable or lawful. B, obtains full details about the current Kiambu County valuation rule, including when and how it was prepared, who prepared it, when it took effect, and where residents can inspect it. C, confirms whether public participation was undertaken during its preparation and provides supporting evidence. D, investigates any enforcement actions taken or planned regarding the new rates. E, recommends that the previous rates of 1,500 per plot remain in place until the county government complies with the legal requirements of public participation, fair taxation principles, and valuation processes. And finally, initiates legislative intervention to streamline the process of setting land rates. Honorable Senators, pursuant to Standing Order 238-1, I commit the petition to the Standing Committee on Land, Environment, and Natural Resources for consideration. And in terms of Standing Order 238-2A, the committee is required in not more than 60 calendar days from the time of reading the prayer, which is today, to table its report in the Senate for